This courtroom hearing starts like many others, but it quickly turns into a cautionary tale about defiance, denial, and the real consequences of ignoring the law. The woman standing before the judge is on probation, already given a second chance by the court. Instead of taking that opportunity seriously, she walks into the courtroom convinced that the rules don't apply to her. From the beginning, tension fills the room. She refuses the help of her public defender, insisting on representing herself, even as the judge patiently explains courtroom procedures and her legal rights. Confident but unprepared, she declines to make an opening statement and presents no evidence, no witnesses, and no real defense at all. Instead, she leans on familiar, sovereign citizen, claims, questioning the court's authority and jurisdiction, arguments that courts have rejected time and time again. As the hearing continues, the situation gets worse. A court services officer testifies that she tested positive for methamphetamines, admitted to drug use, failed to report to probation as required, and was even arrested for a new offense. Each violation chips away at any chance she had of leniency. The facts are clear, and the record speaks for itself. The judge listens, reviews the evidence, and delivers a firm ruling. She is found to be in substantial violation of her probation. The courtroom goes silent as the judge orders her immediate arrest to serve her underlying sentence. As deputies move in, she makes one last defiant claim, insisting she should be paid for every minute she spends in jail, a statement that only highlights how disconnected she is from reality. This video is a powerful reminder that courts operate on law and evidence, not beliefs, and ignoring that truth can cost you your freedom.
Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm gonna make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement? State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Ms. Clark?
it was positive for methamphetamine.
So her
stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
This courtroom hearing unfolds as a stark reminder of how quickly confidence can turn into consequence when it is built on denial instead of reality. The woman at the center of this case walks into the courtroom already on probation, a position that exists only because the court previously chose leniency over incarceration. Probation is not freedom in the usual sense. It is a conditional trust, one that requires strict compliance, honesty, and accountability. From the very beginning of this hearing, it becomes clear that she does not see it that way. She presents herself with an air of certainty, speaking as though the rules that govern everyone else somehow stop at her feet. The judge begins by addressing her rights, ensuring she understands the seriousness of the proceeding and the potential consequences she is facing. One of the most important of those rights is legal representation. A public defender is available, trained and experienced, ready to speak on her behalf and challenge the allegations using proper legal arguments. Instead of accepting this help, she immediately rejects it. She insists on representing herself, brushing aside the judge's warnings about how difficult and risky that decision can be. The judge remains patient, explaining that the courtroom operates under specific procedures and that probation violation hearings are not informal conversations. Evidence matters. Testimony matters. Legal standards matter. None of that seems to register. She responds with confidence but without substance, giving the impression that she believes belief alone is enough to shield her from consequences. As the hearing moves forward, the absence of preparation becomes impossible to ignore. When given the opportunity to speak in her own defense, she offers no structured argument. There is no opening statement outlining her position. There is no attempt to explain or refute the allegations in a meaningful way. She does not call witnesses. She does not present documents. She does not challenge the evidence using legal reasoning. Instead, she leans entirely on familiar, sovereign citizen rhetoric, questioning whether the court has jurisdiction over her at all. These arguments, while delivered with confidence, have no legal foundation. Courts across the country have consistently ruled that such claims do not exempt individuals from the law. Jurisdiction is not a matter of personal belief, and consent is not required for the court to enforce criminal judgments. The judge allows her to speak, but it is clear that these claims are not helping her case. If anything, they highlight her refusal to engage with reality. The focus then shifts to the testimony from court services. A probation officer takes the stand and calmly lays out the facts. There is no emotion in the delivery, just documentation and verified records. The woman tested positive for methamphetamines during a drug screening. This alone constitutes a serious violation of probation terms. Drug use is not a minor technical error, it is often one of the core conditions probation is designed to prevent. The officer continues. She admitted to using drugs. She failed to report to her probation officer as required, missing scheduled check-ins without approval. Reporting is not optional. It is how the court monitors compliance and progress. Failing to report signals avoidance and disregard for the conditions she agreed to. The testimony does not stop there. While still on probation, she was arrested for a new offense, compounding an already serious situation. Each point is supported by records, dates, and admissions. There is no confusion about what happened. The violations are not alleged in vague terms, they are documented and clear. As this information is presented, the woman does not meaningfully dispute it. She does not deny the failed drug test. She does not contest the missed appointments. She does not offer an alternative explanation supported by evidence. Instead, she returns again and again to arguments about authority and jurisdiction, as if repeating them might somehow erase the record. The judge listens carefully, allowing her time to speak, even as her responses drift further from anything legally relevant. The court is not there to debate philosophy or personal interpretations of law. It is there to determine whether probation conditions were violated. On that question, the evidence speaks loudly. As the hearing progresses, the contrast becomes stark. On one side, there is documented testimony, verified tests, and official records. On the other, there is belief, defiance, and refusal to acknowledge basic facts. The judge's tone remains measured, but the direction of the case becomes increasingly clear. Probation is not an endless series of chances. It is a final opportunity to demonstrate responsibility. According to the evidence, that opportunity was repeatedly ignored. When the judge finally delivers the ruling, it is direct and unmistakable. She is found to be in substantial violation of her probation. The violations are not minor, technical, or accidental. They represent a pattern of non-compliance, dishonesty, and disregard for court orders. As a result, the court revokes probation and orders her to serve the underlying sentence that probation had temporarily suspended. The atmosphere in the courtroom shifts instantly. What moments earlier felt like an argument now becomes reality. Deputies step forward to take her into custody. This is the moment where belief meets consequence, where ideology offers no protection against enforcement. As she is placed under arrest, she makes a final defiant remark, claiming she should be paid money for every minute she spends in jail. Rather than helping her case, the statement underscores how disconnected she is from the situation. Jail is not a transaction. It is not something the court owes compensation for. It is the result of legal findings based on evidence and law. The judge does not respond to the claim because there is nothing to respond to. The decision has already been made. This hearing serves as a powerful example of how the justice system operates when faced with defiance unsupported by facts. Confidence without preparation is not a defense. Personal belief does not override court orders. And probation, while generous, is not unconditional. The courtroom does not bend to ideology, emotion, or repetition. It responds only to law, evidence, and accountability. What makes this case especially striking is how avoidable the outcome was. Legal counsel was offered. Clear explanations were given. Opportunities to comply existed long before the hearing ever took place. Yet each chance was ignored in favor of confrontation. In the end, the system did exactly what it is designed to do when probation fails: enforce the sentence that was already waiting. This is not just a story about one defendant. It is a reminder that the courtroom is not a stage for protest theories or symbolic resistance. It is a place where actions are weighed, records are examined, and consequences are enforced. When someone refuses to engage with that reality, the outcome becomes almost inevitable.